You don't have a case. You don't have a lawyer. And honestly, you don't have a chance. So do yourself a favor and walk away before this gets embarrassing. The man who said that was wearing a $3,000 suit in a conference room on the 14th floor of a building in downtown Ottawa. He was 54 years old. He had never lost a labor arbitration in 11 years. And he was talking to a 28-year-old black woman who had arrived carrying a canvas tote bag, a highlighter, and a water bottle. He thought he knew exactly what that meant. He was wrong. Tasha Beaumont-Reid had served 2 tours in the Canadian Armed Forces before she was 25. She had done things in uniform that she couldn't talk about and wouldn't. After she came home, she spent 3 years working as a corrections officer at a federal facility outside of Kingston, Ontario, where she learned something that the Army hadn't taught her: that the most dangerous systems aren't the ones that shoot at you. They're the ones that smile while they take everything you have and then ask you to thank them for it. She left corrections in March. Not because she wanted to, because they made her leave. The official reason, documented in a 12-page termination notice, filed by Hargrove Institutional Services, the private contractor that managed staffing at the facility, was conduct unbecoming and breach of protocol. What actually happened was that Tasha had filed a formal complaint against a senior supervisor named Conrad Pelletier, who had been falsifying incident reports for at least 2 years, covering up in-custody injuries that should have triggered provincial investigations. She had documented everything. She had names, dates, shift logs, and a binder full of cross-referenced incident numbers. 2 weeks after she submitted the complaint, she was terminated. Conrad Pelletier got a commendation. The arbitration hearing was scheduled for a Thursday in late November. Tasha had 60 days from her termination to contest it through the Provincial Labor Board. She had used all 60 of them, not to grieve, to prepare. She couldn't afford a lawyer. The ones she called told her the same version of the same thing. Hargrove had deep pockets and a firm on retainer. Fighting them was expensive. Winning was unlikely. One of them, a labor specialist in Barrie who had kind eyes and a tired voice, told her plainly, "I took a case against Hargrove 3 years ago. They buried it in procedural delays for 14 months until my client ran out of savings. I'm sorry, I want to help you, but I need you to understand what you'd be walking into." Tasha thanked him and hung up. Then she opened her notebook. She had kept a notebook since the forces. A habit from training. Write everything down, because memory is unreliable and the debrief comes later when you're tired. In civilian life, the notebook had followed her everywhere. To shift briefings, to incident reports, to the conversations she'd had with Conrad Pelletier that she'd documented word for word the moment she got home, because something in her gut told her she'd need them. That notebook and 2 boxes of printed records and a 3-month education in Canadian labor law that she'd given herself at the Ottawa Public Library were what she brought to the 14th floor. Before she walked in, she'd spent 12 weeks doing something that no one expected her to do. She read. She read the Canada Labor Code. She read provincial arbitration case law. She read Hargrove's own internal policy manual, which was publicly filed with the Labor Board as part of their operating Avanton agreement. She read the Corrections and Conditional Release Act. She read every Hargrove Institutional Services that had been published in the last 8 years. There were 6. Hargrove had won all 6. The same arbitration firm had been used in 4 of them. And in 3 of those 4, the presiding arbitrator had been a man named Douglas Finn. Douglas Finn was the arbitrator assigned to Tasha's case. She had found his name on the appointment notice and written it in her notebook with a question mark beside it. Then she started reading. What she found, she almost set aside. It felt too large, too deliberate, too much like something that only happened in movies or in stories people tell to make a point. But it was there, in the public record, filed with the Federal Conflict of Interest Registry. She read it 3 times before she wrote anything down. Then she wrote it down. The morning of the hearing, Tasha's mother called at 6:45. Yvonne Beaumont-Reid was 61, a retired nurse from Brampton, who had spent 30 years working nights at a hospital that kept cutting staff and raising executive salaries. She had opinions about that. She had opinions about most things. "You eat?" she asked. "I'm about to." "You sleep?" "Some." A pause. Yvonne had learned not to push. "You ready?" Tasha looked at the canvas tote on her kitchen table. The binder, the highlighted pages, the notebook, the single piece of paper she had folded and placed in the front pocket of the binder 2 nights ago when she had found what she found. "Yes," she said. "Good." Her mother's voice was even. "Then go show them who you are." The conference room on the 14th floor was arranged the way these things always were. Long table. Hargrove's legal team on one side. 2 lawyers, a junior associate, and a HR representative, who didn't look at Tasha once. A court reporter in the corner. And at the head of the table, Douglas Finn, 60 years old, silver-haired, the kind of man who had spent so long being the most important person in every room he entered that he had stopped noticing it. He looked at Tasha's tote bag. He looked at the absence of anyone beside her. He looked at the water bottle. Something moved across his face. Not cruelty, exactly. Closer to the expression of a man who already knows the score of the game. "Mrs. Reid," he said, "before we begin, I want to make something clear. This proceeding follows strict evidentiary standards. Emotional accounts and personal grievances, while understandable, are not evidence. If you intend to represent yourself, you'll need to operate within those parameters. I won't be making allowances for inexperience." He said it gently. Was the thing that stuck. He said it like he was doing her a favor. Hargrove's lead counsel, a woman named Victoria Marsh, opened with a presentation that lasted 40 minutes. It was polished and precise and designed to make Tasha's termination look not just justified, but inevitable. She had slides. She had the 12-page termination notice. She had a statement from Conrad Pelletier describing Tasha's conduct as disruptive, insubordinate, and damaging to staff morale. She had a letter from a senior manager corroborating the same account. She didn't look at Tasha once while she spoke. She talked about Hargrove's commitment to institutional integrity and their zero-tolerance approach to protocol violations. She talked about Tasha's termination the way you'd describe taking out the trash. Necessary, routine, already forgotten. When she sat down, Finn turned to Tasha. "Ms. Reid, your opening." Tasha stood. She didn't have slides. She didn't have a printed brief. She had her notebook open on the table in front of her, but she barely looked at it. "I worked at that facility for 3 years, she said. "I completed 2 tours overseas before that. I know what a chain of command looks like, and I know what it looks like when someone uses a chain of command to bury the truth. What happened at that facility wasn't a conduct issue. It was a cover-up. And the records I'm going to walk you through today didn't come from my memory. They came from Hargrove's own filing system." She paused. "Mrs. Marsh says this is about protocol. She's right. The question isn't whether protocol was broken. The question is who broke it and why." The room was very quiet. Finn's expression didn't change, but something in it had shifted, just slightly. He had expected tears, maybe, or stumbling, or the kind of anxious over-preparation that collapses the moment anyone pushes back. He had not expected that. Tasha sat down and wrote a single word in her notebook. Steady. The morning session was a technical exercise in endurance. Victoria Marsh called Conrad Pelletier to give a statement. He was a big man, broad-shouldered, the kind of person who had learned early that physical size was a form of authority. He sat down and spoke about Tasha the way people speak about inconveniences. She had been difficult. She had escalated minor issues into formal complaints. She had created a hostile atmosphere for other staff. He never raised his voice. He was very calm. He had rehearsed this. Tasha watched him. She wrote nothing. She had learned in the forces that the most important thing in an interrogation isn't what you say. It's what you don't say, and when you don't say it. When it was her turn to cross-examine, she stood slowly. Mr. Pelletier, the incident report filed on October 9th of last year. Case number 2023, KNG 0847, lists the cause of a detainee injury as self-inflicted during routine movement. Is that accurate? He nodded. That's correct. You filed that report? I reviewed and approved it. Yes. And the CCTV footage from the corridor where that incident occurred. Is it standard practice to retain that footage for 30 days? Standard practice, yes. The footage for that corridor, for that date, was overwritten after 9 days. According to the facility's own retention log, which I requested from the Labor Board's document disclosure. She held up the printed log. Can you explain the discrepancy, the first crack? Small. Just a pause that lasted half a second longer than it should have. Equipment malfunction, Pelletier said. It happens. It does, Tasha agreed. I also have the incident reports from March 17th, July 4th, and August 22nd of the same year. All three list detainee injuries as self-inflicted. All three have corresponding CCTV retention records showing footage that was overwritten before the standard 30-day window. 3 equipment malfunctions in 9 months, same corridor, same supervisor on shift. She placed the printed pages on the table, one at a time. That's not evidence of malfunction, Mr. Pelletier. That's a pattern. Marsha was on her feet. Objection. The claimant is speculating without expert. The documents are Hargrove's own records, Tasha said evenly, filed with the Labor Board during disclosure. I'm not speculating. I'm reading. Fenn looked at the pages. He looked at Pelletier. He said, "Continue, Ms. Reed." Tasha continued. She walked through 4 incidents in 40 minutes. Each one cross-referenced with the retention log, the shift schedule, and the facility's own internal policy on mandatory reporting. By the end, Pelletier had stopped making eye contact with anyone at the table. His answers had become shorter and more careful, the way answers become when a person realizes they've already said too much. Fenn called a midday recess. In the corridor, Tasha sat on a bench near the elevator bank and drank from her water bottle. Her hands were steady. She had been trained to keep her hands steady. Her mother had driven up from Brampton that morning and was sitting 2 seats away, her coat still buttoned, her purse on her lap, watching the elevator doors like she expected something to come through them. "You're doing it," Yvonne said. "I haven't done it yet. I know what I'm watching, Tasha." Tasha looked at the binder in her lap, the front pocket, the single folded piece of paper. "There's one more thing," she said. Yvonne looked at her. "It's big." "How big?" Tasha thought about the Federal Registry, the filing date, the number she'd copied into her notebook at 2 in the morning at her kitchen table, when the apartment was quiet and the city outside was dark, and she had sat very still for a long time after reading it. "Big enough that I almost didn't believe it," she said. "And I found it in a public record. Anyone could have found it. No one looked." The afternoon session began with 40 people holding their breath, though most of them were holding it in their own offices and living rooms, and didn't know yet what they were waiting for. Fenn called the session to order. Marsh straightened her papers with the confidence of someone who believed the morning had been a setback, and nothing more. Pelletier was back in his seat. The HR representative was back to not looking at Tasha. Tasha stood. "Arbitrator Fenn," she said, "before closing arguments, I'd like to enter one additional document into the record." Fenn raised an eyebrow. "Proceed." Tasha reached into the front pocket of her binder and withdrew the folded piece of paper. She unfolded it once and placed it flat on the table. "This is a public filing from the Federal Conflict of Interest and Post-Employment Registry, a disclosure submitted annually by individuals who hold appointments to arbitration panels under federally regulated labor boards." She looked at Fenn directly, "including this one." The room changed, not loudly. There was no gasp, no dramatic sound, just the particular quality of silence that happens when people in a room understand, almost simultaneously, that something has shifted. According to the disclosure filed under your name, Arbitrator Fenn, you hold a personal investment in Hargrove Institutional Services through a holding company registered in your spouse's name. The declared value is $93,000. The filing date is 8 months ago. She paused. Hargrove is the respondent in this proceeding. A ruling in their favor increases the value of that investment. A ruling against them does not. Fenn's expression did not collapse. Men like Fenn don't collapse. But something left his face. Some quality of ease that had been sitting there all morning, the comfortable certainty of a man who believed the outcome was already written. This filing, Tasha continued, is a matter of public record. It was available to anyone who requested it from the registry. I requested it 6 weeks ago. She set the paper on the table and pushed it gently toward the center. My question, Arbitrator Fenn, is a simple one. Under the Conflict of Interest Act and the Labor Board's own Code of Conduct for appointed arbitrators, a financial interest in any party to a proceeding requires mandatory disclosure to all parties and mandatory recusal before the hearing begins. Neither of those things happened. She looked at him. She didn't look away. How is this proceeding fair? Douglas Fenn's hands were flat on the table. He was very still. The court reporter had stopped typing. Victoria Marsh was staring at the document in the center of the table, with an expression that Tasha had seen once before. On the face of a soldier who had just realized the road they were on wasn't the road they thought it was. Marsh had worked with Fenn on 4 Hargrove cases over 6 years. She had never once checked his financial disclosures. Why would she? He was the arbitrator. He was the authority. You didn't audit the authority. You didn't until someone did. This proceeding, Fenn said, and his voice was measured and careful in a way it hadn't been all morning, is in recess. He gathered his materials. He stood. He walked to the door without looking at anyone at the table, and he left. What happened after that unfolded quickly in the way that institutional collapses always unfold. Everything at once, and then the long silence. The Labor Board was notified that afternoon. An emergency review was filed by end of business. A replacement arbitrator, a woman named Justice Adiezi Obi. Tasha caught herself. Not that name. She had a list. A replacement arbitrator, a woman named Justice Renee Fontaine, was appointed from the federal roster in Montreal. She reviewed the full record within 48 hours. Pelletier's testimony, the retention logs, the cross-referenced incident reports, the conflict of interest disclosure, the pattern. Her decision was 11 pages long. Tasha's termination was overturned. The stated grounds, conduct unbecoming and breach of protocol, were found to be unsupported by the documentary record and inconsistent with the facility's own policies on whistleblower protection under federal statute. Hargrove was ordered to pay 22 months of back wages and to cover Tasha's documented costs for the proceeding. Justice Fontaine further recommended that the Pelletier incident reports be referred to the Correctional Investigator's Office for independent review, and that Douglas Fenn's appointment history be audited for undisclosed conflicts spanning the previous 6 years. That audit found 4 cases. All 4 had been ruled in favor of Hargrove. All 4 involved Black or Indigenous workers. All 4 terminations had been upheld. Every one of them was reopened. Conrad Pelletier resigned before the correctional investigator completed its review. He issued no statement. He left quietly, the way people leave when they know what's coming. Douglas Fenn's appointment to the Federal Labor Arbitration Panel was suspended pending investigation. 18 months later, his appointment was permanently revoked. The regulatory body's finding used language that was careful and formal and said, plainly, that he had used the authority of his position to protect a financial interest at the expense of the workers whose cases he was entrusted to adjudicate. His name was removed from the panel registry. Tasha found out about the final ruling on a Tuesday morning in February. Her mother called first before the official letter arrived. "It's done," Yvonne said. "I know. How do you feel?" Tasha was standing in her kitchen. Outside, Ottawa in February was exactly what it always was. Gray sky, salt-stained sidewalks, the particular cold that settles in between the buildings and stays. Through the window, she could see the corner store where she had bought coffee every morning for the 6 months she'd spent preparing, cross-referencing, reading case law at 2 in the morning with a highlighter and a cup of tea that had gone cold. "Like I want to sleep for a week," she said. Her mother laughed, and Tasha laughed too, and for a moment it was just that. 2 women laughing on the phone in February, and everything that had been held tight for months releasing all at once. "There's something I want to say before we go, and I'm going to say it plainly. I've been covering stories like this one for a while now. Stories about ordinary people who ran into a wall, a system, an institution, a powerful name, and decided to push back instead of walk away. I tell them because they're true, or because they're true enough, because the machinery they describe is real even when the names are changed. What gets me about this story every time is not the ending. The endings in these stories are never as clean as they sound when I summarize them. There are still 4 families trying to rebuild. There are still months of back wages that don't replace what stress and uncertainty cost a person. There is still a woman who spent 6 months doing the work of a legal team by herself at her kitchen table because she couldn't afford anything else. What gets me is the moment in the corridor, Tasha sitting on that bench with a water bottle and a binder, her mother 2 seats away, knowing that the most important thing she had found was sitting folded in a front pocket. And she had found it in a public registry, open to anyone, available to every lawyer who had ever walked into a room with Douglas Finn and assumed that the authority in front of them was clean. No one looked, until she did. If you've ever been told your complaint was too small, your evidence too thin, your position too weak-minded to bother fighting, this story is for you. If you've ever been the person in the room without the credentials, without the retainer, without anyone sitting beside you, you already know what it costs to stay in the chair. You know what it takes to keep your hands steady when everything in the room is designed to make you feel like you don't belong there. Tasha belonged there. She had always belonged there. She just had to prove it to people who had already decided otherwise. Hit like if this one meant something to you. Share it with someone who's been underestimated. And drop a comment below. Have you ever had to fight a system that was set up to beat you before you walked in the door? I read every single one.